Hello everyone, today we would like to discuss the objective international private rules of the European Union. We will focus on two regulations. That is first Regulation 1215/2012 and second that is Regulation 593/2008. In other words, we talk about the Brussels I and the Rome I regulation. The idea of objective private international rules is that if you have a legal conflict with someone from another country within the European Union, you know where to sue this person and what legal system then will be applied. These are basically two distinct questions. So the first question is what court has jurisdiction, and the second question is what legal system will be used to solve this legal dispute. There could hypothetically also be a third question, that is, how can you execute a verdict when you have a verdict from a court in another country? But within the European Union, this is not much of a problem because in Europe we've agreed to accept one another's verdicts. If a court in Germany, for instance, convicts me of a certain misbehavior and I have to pay a fine, the Dutch courts will always reaffirm this German verdict. I propose to solve these issues with a three-step approach, the so-called Dr.wernaart approach. And basically it's very simple. It's like dating a girl or a boy, whatever which you prefer. Just imagine you walk into a bar, you're single, you're a bachelor, and you want to date someone. Preferably, you have a crush already on someone. So when you enter the bar, you basically walk towards that person of your choice and you start dating that person. However, if you fail to do that because you do not have a crush on someone, you might just go into that bar and try to date someone more randomly. But obviously, you have a certain selection of criteria which you prefer in a date. Maybe he or she should have brown hair, blue eyes, be very muscled, or some other features. So you've made a selection, and out of that selection, you predominantly choose those which you would like to date. If that doesn't work, because you utterly fail in dating that person, you just randomly pick someone. Well, it sounds like a very strange comparison, but this is exactly the way international objective private rules work. And here's why. So, in essence, we have a three-step approach. First, you basically choose the one you date. Second, you have fixed criteria regarding those which you might date. And third, you just don't know who to date, you just randomly pick someone. This three-step approach will now be translated to law. Just mind you, you need to do this three-step approach regarding both questions. So, what court has jurisdiction is question one. And what law would be applicable is question two. And in each case, you just use this three-step approach. However, you use the Brussels I regulation for figuring out what court has jurisdiction, and you use the Rome I regulation to figure out what law will be applied. Step one, if you have a legal conflict with another party in another country, but within the European Union, you might simply agree on what court has jurisdiction and what law will be applied. As a matter of fact, in most B2B contracts, this is very normal to select this beforehand. So you have a business deal and you already specify in the contract, if we ever end up in a conflict, then this is the court where we go to and this is the law that will be applied. Well, if that's the case, the choice has already been made. You've selected actively what you would like to do in case of a legal dispute. Well, there is this principle of free choice in law. So it means that you can basically choose this and this will then be applied. In normal situations, your search will stop here. So you basically do what's in the contract. We go to that court or we apply this particular legal system. One little side note, legal system does not necessarily have to be a national legal system. It could also be an international document such as Incoterms or the CISC, the Convention on the International Sales of Goods, something like that. Step two, if the conflicting parties did not make a legal choice, you will have to dig into both the Brussels I and the Rome I regulation to figure out if there is a specific rule for this particular type of contract. And I can be very short in that. We usually have particular rules, we call them lex specialis, when it relates to a business-to-consumer contract, an employment contract, a transport contract, insurance contracts, or immovable property contracts. If it's one of those contracts, you can rest assured there will be specific legislation about these particular type of contracts. So, for instance, when you have a legal dispute that relates to a consumer contract, so that is B2C, and in the contract you already have, we did not specify what court has jurisdiction and what law will be applied. we have to turn to Article 17 of the Brussels I regulation that will specify how to deal with matters on consumer contracts. And we have to turn to Article 6 of the Rome I regulation that will specify what law will be applicable in case of consumer contracts. Those are referred to as leggi specialis. If you cannot find a lex specialis because it simply doesn't exist in those two documents, you go to the lex generalis. These are basically always the same. So in case of the Brussels I, we will always turn to Article 4 in combination with Article 7 to figure out what court has jurisdiction in this particular general case. When it relates to the Rome I, we have to also look in Article 4. So, for instance, Article 4 of the Brussels I regulation specifies that you can always sue another party in another European Union country in the country where this party is domiciled. On top of that, you may have an alternative choice, which can be found in Article 7, where you can also sue the party in any other given country. For instance, the first paragraph of Article 7 in Section 1A specifies that you can also sue someone in the country where the particular performance of the contract should be carried out, should take place. So that leaves you two options. You can either sue this person in his home country or her home country, and on top of that, you can make a choice to sue this person in the country where the characteristic performance of the contract should be carried out. These are lex generalis, so in essence, they can always apply if you cannot make a choice or no choice was made and you cannot find any lex specialis. So when we turn to the Rome I, the one you use to figure out what law will be applicable, you can find in Article 4 that in the case of a contract that relates to the sales of goods, you will always use the applicable law of the country in which the seller lives, has his habitual residence. This is a lex generalis. To sum up, step 1, if the two conflicting parties made a legal choice about either the jurisdiction or the law that will be applicable, you basically apply this choice, you respect the choice. End of story. So in the absence of a legal choice, you go to step 2. Can you find a lex specialis in both the Brussels I and the Rome I when it relates to either the jurisdiction or the law that's applicable? If the answer is yes, then you apply this particular rule. If the answer is no, you go to step 3. And you basically use the general rules we in general have in both the Rome I and the Brussels I. However, there's only one small minor exemption, as we always will see in law. That is that sometimes in contracts the weaker party is additionally protected. This only applies to the Rome regulation, the Rome I regulation, not to the Brussels I regulation. So this means that in case you've made a choice as to the jurisdiction, this will always apply. However, in certain contracts, there is a disbalance in the power position of the two conflicting parties. For instance, in a business-to-consumer contract, we always consider the consumer to have a weaker position compared to the business. After all, the business will probably select in their general terms what law will be applicable, which is not negotiable for the consumer. A second example could be the relation between an employee and an employer. The employer usually is more powerful than the employee. It's usually a take it or leave it contract, and you cannot really negotiate what law will be applicable in your contract. In those two cases, which you can find in Article 6 and Article 8 of the Rome I regulation, by the way, impossible to read, you will find these exemptions, and what they basically tell you is that if the weaker party is confronted with a choice made by the stronger party, a choice for a particular law, the weaker party might invoke the law that would be normally applicable in either his home country in case of a consumer or the country in which the employee usually works. If those if the rules of these legal systems are more favorable to either the consumer or the employee, the choice made by the more powerful party, that is the business or the employer, will be replaced with the more favorable rules of the other legal system. I hope you've learned something about objective private international rules today, especially in the context of the European Union. If you'd like to see some more information, just check www.drwernaart.com or like Dr. Wernaart at Facebook. That is www.facebook.com/drwernaart. Thank you very much for watching.